So Patrick's told us what the metaverse is and how it can be utilised. I'm going to be looking at how the intellectual property offices, the IPOs, have reacted. Gallop through some case law. There's not very much, so it won't take too long. And I'll finish up with some thoughts about how you and your brand or your client's brand can be protected in the metaverse. So effectively, as we said right at the start, we're dealing with a whole new world. It's a new start, and inevitably there are new rules. So what I'm going to do is take us what it looks like practically in these new rules, what the courts think, and what we can do to protect ourselves and our clients. Next slide, please. So the new world and new rules. The IPOs around the world have reacted as they started to receive an increasing number of trademark applications for metaverse goods or virtual goods in the metaverse. So the IPOs have issued directions. So I've rather bravely put the UK Union Jack between the European Union flag and the United States flag. In fact, the UK IPO was a little bit slower in confirming its position. It wasn't until March this year. The EU IPO and the US PTO and the Benelux office and the Brazilian office were all a little bit quicker off the mark, and they issued their statements in 2022. But importantly, they've all been very consistent in saying that virtual goods belong in class 9, which is the software class. Next slide, please. So I thought it would be interesting to have a look at an actual specification for showing virtual goods and services. So Patrick has showed us that virtual goods can be absolutely anything: training shoes, t-shirt, cars, sports equipment, burgers, plates, houses, furnishing, and land. They're all virtual, so they're all software, and that includes the NFTs. So the IPOs have been saying that the type of virtual goods, and including the goods that are authenticated by NFTs, must be specified. And for those who work with the EU IPO, you'll know that the EU IPO has always been very keen on having precision and clarity in its specifications. So there's nothing new in this. Let's look at the McDonald's specification. So in class 9, we have virtual food and beverages, and I have to do a little bit of blink there to start off with, because you think food and beverages, why are they in class 9? Of course they are, they're virtual. Then you look at the class 41 services. I think these are actually quite interesting. You can go to a virtual restaurant and you can wear McDonald's clothing if you want to. You can actually attend a virtual or an actual concert. And look at that specification in 41, the last term: operating a virtual restaurant featuring virtual home delivery. And then go down to the class 43, and here's the blend of the worlds that Patrick was talking about earlier: operating a virtual restaurant featuring actual home delivery. So quite amazing. Here's the IPOs reacting, and you can see that in the specifications. Next slide, please. So here we have the another specification. This one is actually a very long specification. It belongs to Gucci, and you can see the Gucci interlocking G's there on the right. I've cut down the specification simply because it's too long to put on. But if you look in class 9, you can see that they have these downloadable virtual goods with a number of assets. And here is Patrick's real estate, lands, all for use in online games. And look, there's that wording, also being authenticated by NFTs. Look at the class 35. Here you are again. There's the first term, online retail store services featuring games and stores. There's nothing too exciting about that. But look at the next one, online retail store services featuring virtual assets, virtual real estate and lands. And there is the authentication by NFTs again. So I think it's a very, very interesting specification. Let's have a look at what the courts are saying now that we've looked at what the IPOs have said. So the courts, the IPOs have said that protection is to be given to virtual goods and services. But what if you're not in the metaverse? What if you're selling actual clothing, actual cars? So you've got, for example, registrations in class 25 for clothing, class 12 for vehicles, and you may well have as well class 35 services, online retail and retail store services. So you're fine, aren't you? Or what if you've ventured into the metaverse and you're selling your virtual goods and you've got virtual protection? Sorry, you've got traditional protection. So that, by that, I mean the class 12, the class 25. Again, you're fine, aren't you? Well, we know what the IPOs have said. They've said very clearly that virtual protection is class 9, virtual goods. What's the case law? What do the courts say? Well, there's not too much. I told you that at the beginning. So this case, the Hermes and Mason Rothschild, there's been a lot written about this one. I can only, in the time allocated, give a very high-level summary. Clearly, Hermes Birkin bag is on the left, and the Meta Birkin, the furry and colourful bag, is on the right. I think it's fair to say it's not quite in Hermes' usual style. So in this case, Mason Rothschild created NFTs linking to a description of a digital Hermes Birkin bag. And he also registered and used the domain name www.metabirkin.com and social media handles such as @MetaBirkins to promote the sale of his NFTs, the Meta Birkin, so-called Meta Birkin NFTs. And he sold over $1 million worth of these. Hermes were understandably a bit cross. The Birkin bag is highly exclusive. There's a restrictive purchasing ability to it. And of course, it's extremely expensive as well. So Hermes obviously got trademark protection for it in class 18. Class 18 is for actual goods, including, of course, for handbags. But the IPOs, as we've just discussed, have said that virtual handbags belong in class 9. So what happened? Well, to cut a very long story short, the court in this case held that despite not having class 9 protection, Hermes' reputation in the Birkin bag carried over into virtual goods, virtual handbags. And so Hermes prevailed in this case. Next slide, please. So this is the second case. Again, I can only give a very high level summary to it. This is the Juventus Football Club and Blockerus. In this case, Juventus brought a claim against Blockerus, who were also producing, creating and selling NFTs. And these NFTs used Juventus's mark. So Juventus, Juve, and the design of the black and white football team stripe. The NFTs were linked to trading cards, and these featured the former Juventus striker Christian Vieri. So Juventus also were not very happy, and they filed infringement proceedings claiming infringement of the club's registered marks. Notably, Juventus, just like Hermes, did have trademark registrations for its marks, but they weren't in class 9. So again, this is a very similar situation. The court in this case also held in favour of the brand owner, Juventus. And they found that the marks was the goods, the virtual goods, were sufficiently protected through their existing traditional trademark registrations. And quite crucially, I think, Juventus had filed sufficient evidence to demonstrate that its marks were well known. And so they had enhanced protection, and that moved then into Class 9, and it covered goods and services where they didn't have registered protection. So you might be thinking, do we need Class 9? Well, the limited case law looks as if you don't, if you've got a famous or a well-known brand. But I think that's a bit of a risk personally. What if your brand isn't famous or isn't well-known? That's, to me, quite a tricky question. And I think at this point in time, it's quite difficult to know how a court might decide. So let's say you've got a less well-known brand, but like Hermes and Juventus, you've also got traditional trademark protection. So you might have a Class 18 registration if you're in handbags, or as we said, 25 for clothing, or 12 for vehicles. And you might also have Class 35 for online and in-store sales. So is your traditional trademark protection going to be sufficient to deal with an infringer in the metaverse using your brand? We don't have a case for this scenario yet. And there isn't, as far as I know, a comparable opposition at an IPO where that particular situation has been tested. I suspect with no Class 9, no virtual goods, or no virtual goods wording in a Class 35 retail specification, you could be in for quite an unpleasant surprise, having in mind what the IPOs have said. So this becomes a bit about an appetite, your appetite or client's appetite for risk. Next slide, please. And is it worth the risk? Well, a Class 9 filing will give you better protection, enhanced protection. And what we know from the case so far seems to be that if your brand is well known, then you are probably okay. But there's only 2 cases so far. But if you're not famous and you're not well known, then my view will be to err on the side of caution. And you know, these bigger, well-known brands are doing the same. They're also being cautious because, as we've seen, they're busy out there and they're filing and registering trademarks in Class 9 for virtual goods and in other classes as well. So it's not just about risk, it's about costs as well, because filing a trademark application is much cheaper than scrambling and trying to collate your evidence in a case to rely on in an unregistered rights case, where you have to have the evidence to prove your reputation and to prove that your brand is sufficiently well known. And of course, with a trademark registration in Class 9, you don't have to do that. So we've got Class 9 giving you that extra layer of protection, and I would also bolt on virtual retail services in Class 35 as well. So what can you be doing at this point in time? You probably are doing a regular audit of your trademarks. Are your rights up to date? Have you got your latest logo registered? Have you expanded into new products? Have you got trademark protection for those new products? As I said, you're likely doing this, but now bolt on that virtual audit as well. If you think that you are going into the metaverse, or you're concerned about your brand being used without your authority in the metaverse, then my feeling is that you should be filing in Class 9 and in Class 35 so that you are prepared for entering into this new world.